case briefs, and so much more. LSData's got what you're looking for.
In the 1985 Supreme Court case, Lowe v. Securities and Exchange Commission, SEC, the court was asked to decide whether an injunction against the publication and distribution of newsletters by petitioners violated the First Amendment. The case revolved around the legal distinction between investment advisors, who are subject to regulation to prevent fraud and deception, and publishers of legitimate newspapers and publications, which are typically protected by the First Amendment as long as they are not giving personalized advice. Christopher Lowe, who was convicted of financial crimes, had his firm Lowe Management Corporation's registration revoked by the SEC. The SEC sought to stop the distribution of investment advisory publications, but the district court only partially agreed. The Court of Appeals subsequently ruled that the petitioners were investment advisors and that the exclusion for publishers did not apply to them. Consequently, the case reached the Supreme Court. The Supreme Court held that the petitioners' newsletters did not qualify as investment advisors and were protected under the First Amendment. The Court of Appeals' judgment was reversed, and it was determined that the lower court had erred in its decision. The SEC could not prevent genuine business publications from sharing factual information and commentary on market conditions. Notably, the First Amendment question that was granted certiorari to decide was not addressed in the ruling.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.